Our topic tonight is U.S. engagement with atrocity prevention and the International Criminal Court, two separate but closely related topics, really. There's been obviously a significant amount of attention to the issue, including especially since Ambassador Bolton's speech in the beginning of September sort of announcing the administration's policy toward the ICC. And of course, the speech came against the backdrop of recent developments at the ICC, including a request from the ICC prosecutor to commence an investigation of what's called the situation in Afghanistan, which involves the potential, involves investigating within it, encompassing allegations of abuse of detainees by U.S. personnel in the early 2000s in Afghanistan. The panel tonight is an outstanding panel, obviously. And I will introduce them briefly, and then we'll start. John Bellinger is heads the public international law practice at Arnold & Porter now, but was the legal advisor from 2005 to 2009. And had the misfortune of having to supervise me, among other things.
Boy, did you need a lot of supervision.
Right. Yeah, no, I didn't envy you. And is an adjunct senior fellow in international and national security law at the Council on Foreign Relations. Jane Stromseth is a professor of law at Georgetown, where she teaches constitutional law, justice and accountability for atrocity crimes and international human rights. And from 2013 to 2015, approximately, she served as the deputy in the office of the ambassador at large for war crimes, for global criminal justice, and worked on a variety of issues, including the ICC, but also including South Sudan, Syria, conflicts around the world where atrocities have been committed, and had the misfortune of having to do the transition to me, which was done really spectacularly, and I'll be forever grateful for it. And Susanna Sakuto is the directs the War Crimes Research Office at the EU's Washington College of Law, which promotes the development and enforcement of international criminal law and international humanitarian law. And she teaches international criminal law, procedure, international legal responses to conflict and gender-based violence, and has published widely on issues related to international criminal law and to the jurisprudence and practice of the ICC. So that's our panel. And I wanted to start with a little history by going maybe to John first to talk a little bit about the sort of progression of U.S. policy towards the ICC. So John, you were in the White House in the NSC in the first part of the George W. Bush administration, and then legal advisor in the second 4 years. And I was wondering if you could start by sort of describing the progression within the Bush administration, what happened to cause the change, and sort of what did you see as the advantages and disadvantages of what are now seen as two approaches?
Great. Thanks, Todd, and thanks, Mark and Sean, for having us here tonight. Thanks for everyone for being here. I think history is particularly important in this case because we are, in fact, coming full circle. George Santayana supposedly said, although I think often people say it's misattributed, that those who don't know their history are doomed to repeat it. And in fact, we are repeating a little bit of history, so including the very same players. So it's worth spending a little bit of time talking about where we've been, where we're going, and where we seem to be going back to again. So I'm going to start extremely briefly, just back a little bit further. Recall, U.S. Had long supported the idea of an international criminal court. You can actually look at amendments in Congress supporting the idea of an international criminal court with certain caveats, negotiated during the Clinton administration. David Sheffer, great member participant in ACIL events, was our chief negotiator, worked very hard on the Rome Statute with the U.S. really in the lead, but ultimately, and I think most people, opponents or supporters, felt that it went off the rails, and the United States ultimately voted against the Rome Statute because they felt that it did not give the United States the protections that it needed. The United States ended up being isolated and was one of only 7 countries in the world to vote against the Rome Statute, leaving the United States in 1999 very isolated largely concerns that the prosecutor had too much discretion and not enough control by the Security Council, and we can go into some of that. In 2000, outvoted by everybody else, the Rome Statute then was presented for signature, left the United States the decision whether to sign or not. You'll recall President Clinton ultimately made the decision, even though the United States had voted against the Rome Statute, to sign on the very last day that was open for signature, to sign the Rome Statute, even though the United States opposed it, and then took the unusual step of saying that even though the United States was signing it, that he would not send it to the Senate for Senate approval, and took the even more unusual step of saying that he would recommend to his successor, which at that point after the election in 2000 was known to be George Bush, that President Bush also not send it to the Senate because it was fatally flawed. I sometimes say that that was smoking without inhaling to say that we were going to sign, but we were not going to ratify. So that was the end of the Clinton administration. Signed, but said it wasn't going to be sent to the Senate. The Bush administration came into office. I was the NSC legal advisor at the time. There was immediately a debate, which was sidelined a little bit by 9/11 as to what to do about the Rome Statute. There were people in the Bush administration, including John Bolton and Secretary Rumsfeld, who felt that it was a mistake of the Clinton administration to have signed the Rome Statute if it was not going to be sent forward to the Senate. I think the Clinton administration's position had been, well, maybe sort of like the law of the sea treaty, it could end up being fixed somehow before it was sent to the Senate. So the view, which was ultimately presented to the president in 2002, was what should the U.S. do about this? The harder line position was not only should the United States withdraw signature, but actually try to lobby other countries to prevent the Rome Statute from even coming into effect. At the time that this idea came up in Bush administration, though, there were already 53 ratifications, and so it would have been extremely difficult to have prevented something like 150 countries from ratifying. So I actually wrote the decision memo for the president, so I know what the decision was that the president decided, no, we're not going to do that. We're not going to try to prevent it from coming into effect, but he did approve the recommendation that we withdraw signature, largely because it would withdraw any obligations that we had under the Vienna Convention on treaties as a signatory. That became famously known as the unsigning. As you all know, as experts in international law, you can't actually unsign a treaty because it was signed, but it did make clear that the United States wasn't going to become party. John Bolton was the one who sent that letter, a one-line letter to the Secretary General saying the United States will not become party. And then John has supposedly said that that was the happiest day of his life to do that. A couple things here. That John Bolton statement, Todd and I both worked with him at the time, though, really was not the policy. The policy was to withdraw, but the stated policy of the U.S. government was in a speech that was given by Mark Grossman, which I encourage you all to go back and have a look at, because this was the policy, which is a very moderate, let's work together speech. And I encourage, it was given at CSIS on May 6, 2002, and was not a hardline, let's attack the ICC speech, but simply we're withdrawing signature because of certain concerns. And I'll just read you one line from Mark Grossman. Notwithstanding our disagreements with the Rome Statute, the United States respects the decision of those nations who have chosen to join the ICC, but they in turn must respect our decision not to join the ICC or place citizens under the jurisdiction of the court. And Mark went on to say, there's common ground, let's work together on these issues. From 2002 to 2004, that is not what happened. Ambassador Bolton was in fact largely in charge of our policy and led a very hard line policy towards the ICC. Now, he was implementing a statute that had been passed by Congress, the American Service Members Protection Act, the very draconian anti-ICC piece of legislation, always blamed on George Bush. Every European I know thinks that George Bush drafted the American Service Members Protection Act, including its famous invade the Hague provision. I remind people that before a bill is presented to the Senate, it has to be passed by Congress, and that both Hillary Clinton and John Kerry voted to invade the Hague. before it ever got to George Bush's desk. So this was not something that started in the administration. I can actually tell you that the waiver provisions that waive a number of the harder line provisions in the American Service Members Protection Act are in there because I put them there, because I was the White House negotiator to make sure that there was, in fact, flexibility to do the things that we ultimately wanted to do, which was to waive foreign assistance to certain countries who were helping us in counterterrorism efforts. In any case, 2002, 2004, very tough line approach to the ICC, antagonized a lot of our allies because we threatened to cut off assistance, including, oddly, counterterrorism assistance after 9/11 to countries that we wanted us to help us in the fight on terror. So 2004, President reelected, Secretary Rice and I moved to the White House. She approved a policy at that point that we take more of a let's work together approach on the ICC, implementing the Grossman speech. And as legal advisor, I worked on that for the next 4 years. Now, it helped that within the first couple of months, the United States abstained on UN Security Council Resolution 1593, which referred the situation in Darfur to the ICC. So rather than blocking that, and I will say, without mentioning any names, that there were certain people in the, and I'm not looking at Todd in that way, that there were certain people in the administration who thought the U.S. should block the referral of Darfur to the ICC. But President Bush personally made the decision that he was more concerned about the genocide in Darfur than he was concerned about the ICC. So the United States abstained on the resolution, saying, we think the ICC has got a role in investigating the genocide in Darfur. For the next 4 years, and Todd was with me at my side pretty much every step of the way, I then emphasized using Mark Grossman's speech, which is the reason that I mention it essentially as my script, that we can have a modus vivendi with Rome Statute parties. No one should make any mistake that the United States was going to withdraw from its objections. These were objections that went back to the Clinton administration. They were bipartisan. We were not going to join the Rome Statute. We had specific concerns. We objected to its jurisdiction. But nonetheless, we thought we could work together with Rome Statute parties, and I gave speech after speech on this, saying not only can we work together, you can become party, we are not going to be party, but we certainly share the cause of international justice, and now we even support the investigation in Darfur. And I said, using an exception in the American Service Members Protection Act, saying we will even provide assistance to the Darfur investigation. So I gave so many of these speeches that they started actually getting press attention. And so if you can look at some of these, I'm looking at, this is Wall Street Journal in 2006. U.S. warms to Hague Tribunal. That was after I gave a speech in 2006. 2007, Washington Post. Official floats possibility of assistance to Hague Court. That was after I gave a speech in The Hague. And then finally, 2008, this headline got me in a little bit of trouble. The Wall Street Journal says, U.S. accepts International Criminal Court. This resulted in a copy of this being sent down from the secretary to my desk saying, John, what have you been saying? That was actually based on a line in a speech that I gave that said that we accepted the reality of the International Criminal Court, and I said, the U.S. must acknowledge that the ICC enjoys a large body of international support and that many countries will look to the ICC as the preferred mechanism for punishing war crimes that individual countries can't or won't address. John Bolton, who at that point was out of office, was asked for comment and is quoted in the Wall Street Journal commenting on my speech in which he called it pablum. So anyway, by the end of the Bush administration, we had really pivoted to essentially a let's work together on international criminal justice. We are not withdrawing from our objections. At this point, the military realized that cutting counterterrorism assistance to close allies was a dumb idea. I mean, and Secretary Rice, when asked about this in testimony, said it's a little bit like shooting yourself in the head, which is true. Why would you cut off counterterrorism assistance to your allies? And so the President Bush, using the waiver authority at which we had negotiated in the American Service Members Protection Act, started waiving those restrictions. We said we would work together on Darfur. And so really there was more of a modus vivendi by the end of the Bush administration. I'll just say one last thing. Todd will actually remember this vividly. Our allies actually fought back every step of the way. I found it annoying because I would say to them in Europe, I am holding my hand out to work together on these issues, work with me. But at that point, they were really so enamored with this new court that they really would not even work with us easily. So, for example, even in the Darfur referral resolution, Todd was assistant legal advisor for LUNA at the time. We wanted simply a preambular paragraph that would say, noting that not all Security Council members are party to the Rome Statute. Well, would you think that would be a difficult provision? I mean, it reflects reality, and we said to our colleagues, please work with us on this, and they said, we will not do that. You know, you have to come to us. We will not meet you halfway. So there was a good deal of idealism on the part of the Rome Statute members that we had to work with. I think some of that is a little bit off the rose at this point. So anyway, that takes you through where we were in the Bush administration and handed it off to the Obama administration.
Great.
Jane, you want to go from
Yeah,
there?
I'll take it from there. Yeah. And first of all, I think it was helpful that there had been this movement and change in the Bush administration, a greater willingness to engage with the court. I think the Grossman speech was a very important statement of all the different ways that the U.S. historically had supported accountability, wanted to continue to support accountability. So that made, I think, a very helpful foundation for the Obama administration to build on. So why did the Obama administration opt for more engagement with the ICC, and are there some lessons we can learn from that? I think first and most fundamentally, the Obama administration in which I served, and there are a number of members of the administration, former administration here, had a very strong commitment not only to justice and accountability for the worst international crimes, genocide, crimes against humanity, war crimes, forced recruitment of child soldiers, mass rape, and so forth, but also a deep commitment to trying to prevent these crimes. And obviously there's a link between seeking justice and accountability and trying to send a message that these are unacceptable and to try to deter and prevent these crimes going forward. So there was this very strong, I think, commitment on these issues from the President, Samantha Power, Ambassador Stephen Rapp at the State Department, and many others to really build on the long bipartisan U.S. legacy in committing resources and diplomacy and support to the law and tribunals necessary to hold perpetrators of the worst crimes to account. So then the question was, what is the role of the ICC in all these in these efforts? And I think in moving forward, the administration, building on the developments that John describes in the second Bush administration, decided to engage more intensively with the court to constructively and pragmatically engage and to support the work of the court on a case-by-case basis consistent with U.S. interests and values and law. And why did the Obama administration decide to do this in addition to the overarching commitment to strengthening justice and accountability and atrocity prevention? Fundamentally, because the administration decided working more closely with the ICC was in U.S. interests. And I would sort of identify three ways in which it was in U.S. interests. For one, the ICC had become a key part of the landscape of seeking justice and accountability. Our major allies were a part of it. It was a court that was up and running. It was starting to have some impacts in addressing situations and in seeking justice and accountability. It was part of the terrain of justice. It recognized the primacy of national accountability processes. It was designed to be complementary to national processes, and the U.S. has long supported the importance and the primacy of national accountability processes. So it was basically an important part of the landscape that was part of this larger goal of strengthening justice and accountability. Second, and very concretely, the Obama administration determined that working with the court on a case-by-case basis could advance important interests in justice very concretely in specific situations. Just as the Bush administration had realized that in the case of Darfur, it was really the only effective option. It hasn't been as effective as we'd like it to be, but it was a critical and really the only realistic option. In other situations, the ICC was looking at the atrocities committed by the Lord's Resistance Army, the atrocities in the Democratic Republic of the Congo. And so working with the court on these cases and supporting them was very much in the U.S. interests to advance accountability, to contribute to atrocity prevention in these very concrete situations. And let me just give a few examples of the kind of support that the Obama administration provided. Diplomatically, it publicly expressed support for each of the investigations, cases, and convictions before the court. It expanded the statutory war crimes rewards program, which offers up to $5 million for information leading to the arrest, transfer, or conviction of designated foreign nationals wanted by international tribunals, including the ICC, and named individuals in this regard were 3 members of the Lord's Resistance Army, as well as a Rwandan warlord for his conduct in the DRC. Another example, the U.S. assisted in turning over major ICC indictees. These included Congolese warlord Bosco Ntaganda for atrocities in the Democratic Republic of the Congo, and helping turn over the Lord's Resistance Army commander Dominic Ongwen, who's currently on trial before the ICC. So in these very concrete ways, consistent with U.S. interests, values, law, the administration provided very concrete support to the ICC, I think leading some at the ICC to say, boy, we're getting more concrete support in these cases from a non-party than we get from some parties in similar kinds of situations. At the same time, the Obama administration worked very hard to support complementary processes at the domestic level, including domestically based hybrid courts, such as the ECCC in Cambodia, the AU Senegal Tribunal, which tried Chadian dictator Hassan Habre, domestic courts, mobile courts in the Democratic Republic of the Congo, the hybrid court in Central African Republic. So there were obviously, it's really very much along the lines of the Grossman speech, continuing that important work that's complementary to what the ICC is doing. And finally, a third reason why the Obama administration, I think, believed closer engagement with the court was in U.S. national interests was that by engaging, the U.S. was better able to express its concerns that continued, it had some concerns about the court, and protect its equities. So, for example, the U.S. sent a negotiating team to Kampala, where the negotiations over the crime of aggression took place, and was able to secure a result that made clear that non-parties to the Rome Statute are not covered by the crime of aggression, which was very important to the U.S. And so being at the table, participating, engaging, was a way to advance U.S. Interests. And attending the ASP, the Annual Assembly of States Parties, as an observer gave the opportunity to speak, to express our views, to engage in diplomacy in the sidelines of the meeting, and to continue to sort of advance and protect U.S. interests and concerns. So I think for all these reasons, it was very much in the U.S. interest to participate and support the ICC. And are there some lessons from this experience? I'll just highlight 3 of them. One, the ICC is indeed an important part of the justice landscape. It's one part, but it plays a very significant role, and I'll talk a little bit later about some of the impacts it's having. But it can help to advance justice for atrocity crimes. It can contribute as one mechanism toward greater deterrence and prevention, which is very much in the U.S. interest to see those kinds of impacts. Secondly, because of the principle of complementarity, because of the primacy of national accountability, which the U.S. has long been committed to, it can work in a complementary fashion with the ICC. It doesn't have to declare war on the ICC, as the Bolton speech did. It can, in fact, work in a complementary fashion with the court. And finally, engagement with the ICC, including engagement to express our concerns, is ultimately going to be more effective and more successful to protect U.S. interests than walking away.
Susanna, could I ask you to address obviously it's the same John Bolton, so we've heard some of it's before. What is the same? What is different between the speech on September 10th that we heard and what was happening in the first Bush administration, and what should we make of the differences, do you think?
Sure. So thank you, Todd and Asil, for the invitation to join this conversation. It's been great. I've heard you speak and talk about the history before, but it's always a good reminder of the arc of where we started, in particular the Grossman speech, and then where we've come to. Because as you suggested, I think we're coming not only full circle, but maybe to a slightly more dangerous point. Right, so I think you're right that that obviously, as you mentioned, Ambassador Bolton was quite vocal in his opposition to the court back when the court first came into existence in 2002. In fact, he was, as you talked about sort of briefly, one of the key architects of the famous Article 98 agreements, by which the U.S. persuaded, I think, over 100 countries to sign agreements ensuring that U.S. citizens would have immunity from prosecution by the ICC on pain of losing economic aid, including counterterrorism or military assistance. So it wasn't that there was oomph behind the objection. But I think what's interesting, I think that there was a much more extreme tone to Bolton's more recent comments. And I think this for three reasons primarily, right? First, his threats today are not only against states, right? They also are threats against individual ICC judges and prosecutors involved in investigating U.S. personnel, or, and this is a quote from his speech, any company or state that assists in ICC investigations of Americans. That is a very broad threat, right? That presumably includes officials of U.S. allies, meaning Dutch or French prosecutors, for instance, who respond to requests for cooperation from the court. Or even soldiers from NATO allies who fought alongside Americans in Afghanistan if they are interviewed, for instance, by ICC investigators. By the way, of the 29 members of NATO, only the US and Turkey are not parties to the Rome Statute. So there is an obligation on parties to the Rome Statute to cooperate with the ICC. So again, this is very broad. The threat may actually seem, it's so broad, it could arguably include organizations that share documentation with the court regarding, for instance, victims of Allied strikes in Afghanistan, or even prominent experts in international criminal law, right? Prominent experts who have advised or provided expertise to the court. There are actually a number of US academics who have served as special advisors to the prosecutor of the ICC. Are those people included under the threat? So that's the first reason, the breadth of who it might include. The second reason is that the threats include not only withholding aid, as we saw in the Article 98 agreements, but also a number of other threats. Banning people from entering the US, right? The ICC prosecutors, ICC judges. 2, sanctioning funds that those people might have or hold in the US financial system. And 3, and this is, again, how far the threat extends to criminally prosecuting ICC prosecutors, judges, or those who assist in the investigation of Americans. Now, whether or not the U.S. could actually deliver on those threats I think what is alarming is they send a signal to authoritarian leaders around the world that it's okay to attack independent judiciaries within their own domestic system, even or particularly when they are seeking accountability for atrocity crimes, right? So I think it shows you a whole different nature of the objection to the ICC. Finally, and third, his warnings, and I think this is where I see a danger that we may not have seen in the earlier statements, are based on a host of false claims, which perhaps is falling in line with others in the administration. But they include claims, for instance, that the ICC will claim universal jurisdiction. The ICC does not operate on the basis of universal jurisdiction. It operates on the basis of nationality or territorial based jurisdiction or a UN Security Council referral. Other statements, his warnings were based on threats that the ICC will attempt to prosecute U.S. officials for the crime of aggression. And as we just heard Jane explain, and I was in Kampala at the time, there was a huge mission, U.S. observer mission in Kampala, and through negotiations, through engagement, as you say, gained the clarity in the statute that aggression cannot be charged against non-party actors. So the language, I think, is a whole different level than what we saw in the George W. Bush administration.
So could I ask, and maybe John, maybe this is for you first. So we had the situation as it was in 2002, 2005. We have the situation today, and there are two broad categories of things that are different. One is the experience that the court has had, right, which has been mixed. At best, it's been mixed. And then there's the experience that we've had with cases of particular concern to us, like Afghanistan. So I guess my first question is, how, on the Afghanistan part of it, how does that affect? Were you wrong in 2005 to be cooperating with them? How do you sort of see it now?
Well, obviously, I think John Bolton would say, and he said at the time, and he wrote after he thought we should not have cooperated even at the time. And I get that theory. It's a very purist theory. The idea is, if this court is so flawed that it's bad for us, it ought to be bad for everybody. And, we can't support it on Monday with respect to Sudan, and then if it comes after us on Tuesday, we'll be against it on Tuesday. The decision that President Bush made was a different one. That John's view was essentially an idealistic or ideological position. ICC is always bad. President Bush's view, which was the policy of the Bush administration in the second term, is we do think that the ICC is flawed. And remember, and I always remind our European viewers, this did not start with the Bush administration. The Clinton administration found the treaty was so flawed that they voted against it, and President Clinton signed the signing statement saying, I am not sending it to the Senate. So this was bipartisan view. But Bush administration's view was, yes, it's flawed, and therefore we're not going to become a party, and it shouldn't come after us, and we will fight furiously if it does. But it is the only game in town. Jane alluded to this, that there just are not a lot of other tribunals. We've had a couple of ad hoc tribunals, but there's a lot of international crime in the world where you cannot rely on countries to police themselves. And try as we will to set up international tribunals or to get countries to set up their own justice, we can't do it. So the ICC plays a role in the constellation of international criminal justice that is a flawed one, and it has not lived up to the expectations of its supporters, and it seems to in some ways get even more flawed. But it is, the answer is it's sort of what we have for accountability. So I don't think we were wrong to support it with respect to Darfur, or even to say that we would support it with respect to other investigations. It needs to be reformed and made better, and unfortunately it has not been. Unfortunately, what then has happened is that it has come after us, and I do think that is, I know Prosecutor Bensouda. I think she's a good person, but I think she has politicize the court. I don't think she actually has anti-U.S. animus that I know of. Other people know her better, but I think the political pressure on her was so enormous to be supposedly even-handed, to go after big countries as well as African countries, and she was under huge pressure from African countries to make it not just an African court, and so her answer to that was to succumb to a little bit of the pressure to say she would open an investigation of the United States. I think that was a bad mistake on her part. I don't think she thought down 3 or 4 steps ahead. One of the things I always loved about Todd is he was probably the smartest lawyer in the legal advisor's office who would think 8 steps ahead in the chessboard. And I worry that Prosecutor Bensouda said, look, I'll just open this investigation now. I will get all these other people off my back, but without really, and the U.S. will be mad at me, but this will just go on for a while. I think, unfortunately, that it is bad for the court. It's bad for the cause of international criminal justice. It is going to potentially wreck, not only the U.S. relationship with the court, but the relationship of a lot of other countries with the court. I think John Bolton overreacted. I agree with most of the things that Susan said in her statement. I would have handled this differently, but any administration, Jane can tell me how she thinks the Obama administration might have handled this, but no U.S. president, Republican or Democratic, particularly in an election year, is going to take lying down a prosecutor who says, I'm going to investigate the U.S. Military and U.S. officials for war crimes. They're just not going to do it. That is why a majority of Democrats in 2002 voted for the American Service Members Protection Act, because in an election year, you protect your troops. So, this is a foolish thing of the prosecutor to do, particularly coming up to an election year, to wave this red flag in front of the United States. It was just not well thought through. I think there were lots of reasons that she could have not pushed forward on the investigation in terms of meeting the thresholds of gravity or complementarity. And I think just in terms of the calculus of, what would be good for the court overall and what would be bad for the court, it was a bad decision on her part. So, I do think John Bolton overreacted. If we had concerns, I think these are concerns that could have been made quietly to the court. And they could have been made loudly to the court, but I don't think it was wise to be, and I don't in fact see how it could be possible under U.S. criminal statutes to prosecute prosecutors or judges or other countries or companies. I doubt that line was cleared with any other department in the U.S. government, including the Justice Department. So bottom line, I think our policy was right at the time. The United States is a leader, is, and will be a leader in terms of international criminal justice and accountability. And what John really left out of his speech was the U.S. role in terms of leadership in accountability and international criminal justice. He says, well, we will continue to do these things by supporting national justice, but that is just not a realistic alternative. You can't ask most of these countries to police themselves. You can't ask Syria or another country to go and set up its own national tribunal. So, not surprisingly, I think we had it right in the second term of the Bush administration, and I'm worried that we have gone back to the first term.
Senator, could I ask you, so the prosecutor has to get permission from the court to commence an investigation, and the office filed their brief, I think it was this month, right, November 2017, or approximately a year ago. Mm-hmm. That is way longer that the request has been pending than any of the other requests, which I think we looked at one point, it was like 3 or 4 months was the average.
Yeah, that's right.
And I guess the first question is, what do you make out of that delay? And sort of what does the process hold from here? How does it unfold?
So, I think maybe it's helpful to go back a little bit. in terms of the history of the Afghanistan situation at the ICC. The situation in Afghanistan has been under a process known as preliminary examination for 10 years. So during that process, what the prosecutor does during this preliminary examination process is she examines whether the court has jurisdiction over potential cases arising out of the investigation in Afghanistan, whether the case is admissible, and I'll talk a little bit more about that, and whether, even if both those criteria are satisfied, there are reasons to believe proceeding with an investigation would not be in the interest of justice. Her office took a good long time, actually, to assess these questions. But once she determined that all these legal criteria had been met under the Rome Statute, she essentially had no choice but to submit the request to proceed to the trial chamber. So, and why I say that is because the statute uses mandatory language. The Rome Statute says that a prosecutor shall initiate an investigation unless there is no reasonable basis to move forward. And reasonable basis is a pretty low standard, right? So the prosecutor has, over the years, talked about challenges in verifying allegations related to the subject matter jurisdiction. She's talked about challenges related to the existence of relevant national proceedings. But there were, I think, increasing expectations and perhaps maybe even indications from the bench that in the absence of further national efforts to address the alleged crimes, she moved the situation from preliminary examination to a formal investigation. Otherwise, I mean, 10 years, that's a long time, right? We see that Colombia was in preliminary examination for quite some time, even longer, but there have been justice efforts to deal with the very kinds of cases that the ICC prosecutor might be concerned with. So in late 2007, as you mentioned, the prosecutor submitted her request to initiate an investigation into the situation in Afghanistan. And now she has to do that when to submit the request to a pretrial chamber when bringing an investigation forward on her own initiative, as opposed to a state or a UN Security Council resolution asking her to investigate the matter. And so her request is now before the pretrial chamber of the court. The pending decision, and this is the reason I think this has created so much response and reaction, is in fact expected to authorize the prosecutor to investigate the crimes. As I said, the standard reasonable basis is a pretty low standard. And the crimes include crimes by the Taliban, but it also includes acts of torture and sexual violence committed against detainees by Afghan security forces as well as US personnel. Right, either in Afghanistan or in secret detention facilities on the territory of other state parties, namely Poland, Romania, and Lithuania. So I think the remarks today that we see are on the 10th were likely prompted by the fact that this is the first time in history, right, that of the ICC that the court might actually address abuses committed by U.S. forces and the CIA. But having said that, and I can stop here, I can come back to what happens next, right? Mm-hmm. I think it is true. This is the first time, maybe some argue this is a mistake. I think it was necessary for her to move by virtue of the language of the Rome Statute. But what happens next? You know, how does the process work? The ICC is a court of last resort. It can't step in when another country is genuinely investigating or prosecuting. And this is the key, someone for substantially the same conduct that the ICC is concerned about. So if this moves forward, right, one of the things that the U.S. could do is challenge the admissibility of any case against a U.S. national by showing that it is or has genuinely investigated U.S. military or CIA officials for crimes of torture or sexual violence committed against detainees. So that's possible, right? They could engage with the court and challenge admissibility. The problem, of course, is that the ICC is interested in going after those most responsible and proceedings to hold perpetrators responsible to the extent that they have occurred in the U.S. appear to have been limited to direct perpetrators or their immediate supervisors. Right? Moreover, with respect to the CIA, investigations appear to have been limited to those who have acted beyond the scope of the legal guidance given by the Office of Legal Counsel, and so didn't really extend to those who actually authorized the use of interrogation techniques, which arguably cross over into conduct that could be categorized as torture. Meaning, investigations against the CIA have likely not included the people that the ICC would be most interested in. Right? Those who have developed, authorized, or oversaw the implementation of interrogation techniques by CIA officers that resulted in the commission of crimes. Having said that, right, even if an admissibility challenge were to fail, right, because you can't show prosecution of those higher ups, I think we're very, very, very unlikely to see indictments against U.S. officials. And why do I say that? I think there are a few things to keep in mind. And this is, again, sort of in the weeds of the operations of the Office of the Prosecutor. The prosecutor has said that the focus of the investigation in Afghanistan, as well as in other situations, is on those most responsible for the most serious crimes, right? And here she's got some discretion. So if you look at her report in 2017, the preliminary examination report on Afghanistan notes that anti-government armed groups, Taliban, etc., have been responsible for more than 17,000 civilian deaths since 2009, as well as almost 7,000 deliberate and targeted killings in civilians. Okay? That's the scope or the scale of the crimes committed by, or allegedly committed by non-state armed groups. In contrast, that same report says the information they have allege 54 detained persons were subjected to torture and sexual violence by U.S. armed forces, and 24 subjected to similar crimes by members of the CIA. So given that the crimes committed by the Taliban and other anti-government forces or other anti-government armed groups, they far outnumber the crimes allegedly committed by other actors in the conflict, I think the prosecutor is very likely to focus her efforts on the Taliban first, right? And that approach actually not only makes sense with respect to the policy of going after senior leaders, but it also makes sense and is consistent with the policy of the prosecutor on case selection and prioritization. That policy paper, which she issued in 2016, lays out a series of factors that she will consider when deciding which cases to prioritize. Those factors include international cooperation and judicial assistance to support the office's activities, the office's capacity to effectively conduct the necessary investigations within a reasonable period of time, and the potential to secure the appearance of suspects before the court. None of those factors argue in favor of her investigating the case against U.S. officials, right? It's clear that U.S. will not cooperate in an investigation by the ICC of U.S. nationals. It's not a state party. It has no obligation to cooperate and is actually in many ways, as we heard from Jane, restricted by statute from assisting the court. And this is a lesson that the ICC has learned in its more recent history, where it has tried to pursue an investigation without the cooperation of the state or the broader international community, it has failed, right? Even where the investigation was against a state party obligated to cooperate with the court, which was true in the Kenya case. The Kenya case are a good example. So while the ICC may have access to some evidence of those crimes by interviewing folks outside the U.S., it will likely be extremely difficult for them to prove the case to a beyond reasonable doubt standard without cooperation. On the other hand, there are aspects of the case against the Taliban that make it particularly appealing or easier to prosecute. For crimes against humanity, for instance, the Rome Statute requires that the prosecutor prove that there was a policy to commit an attack against a civilian population. As an evidentiary matter, that would not be difficult, right? The Taliban leadership has expressly declared its policy of attacking civilians publicly in official documents. So there are not just scale, but other reasons that the prosecutor may use her discretion to investigate the Taliban rather than the U.S.
So if, I'll sort of ask it as a general question, if you're the U.S. government and you're concerned about your own personnel being officials or higher level officials being investigated, you have laid out reasons to think it's probably not going to happen, right? But you don't really have assuredness, right? What can be, or maybe whoever wants to answer this question, what can be done? And the U.S. government, like any government in that situation, is always going to be concerned that it's operating under a cloud. So you could say the cloud's not as dark as it might think it is, but there is something of a cloud. What can be done to sort of resolve those kind of concerns? I mean, what if you were, Regina, I'll ask you, if you were, if the prosecutor's office was here right now, where is the ladder? And of course, they have a problem because they do have their rules as they sort of understand them. And in some ways, I think some of the concerns that the United States has are about their rules, right? And the one that would often come to me was, and it may be that our example isn't a good example because there's, there are allegations against American personnel, but if the way they have their system set up, they initiate an investigation, and then who's ever in that country is subject to potentially to the investigation, even if there were no allegations against them originally, right? And you have to sort of then sort of gear up to sort of deal with it. You're sort of under suspicion and all this kind of thing. The idea that because they open an investigation of the situation in Afghanistan, everybody's covered by it doesn't seem to necessarily follow from me, but it's obvious to them. What kinds of things would you advise them to sort of change or to do to sort of, if they wanted a ladder down, what kind of things might they do to sort of find a way off of this?
Well, let me just say a little bit about what I think we should be doing, the U.S. government. But let me also say, as Susanna did, that this preliminary examination was going on for over a decade. I think it started in 2006. So they were kicking the can and kicking the can. And I think the Office of the Prosecutor, as they have said in their policy on preliminary examination, likes to see preliminary examinations as a way of trying to catalyze domestic accountability. That that's a more cost-effective way and ultimately more effective way to seek justice is to have local domestic authorities take action. And I think it's important in the Afghanistan situation, as Suzanne also mentioned, that we're not the only piece of it. The Taliban is a huge piece of it. And if you look at the preliminary examination reports over many years, there was just consistent frustration expressed by the Office of the Prosecutor that they weren't getting information from the Afghans or from the U.S. about what domestic accountability efforts were being undertaken. And they were clearly trying to catalyze and encourage more action in that regard. And so I think the sort of slow path that this took was a kind of an attempt not to cross the Rubicon, but to try to encourage domestic accountability. We've got Liz Evenson here from Human Rights Watch, and Human Rights Watch has done a very excellent study of the sort of catalyzing effects of preliminary examinations in a number of countries, Guinea being one example, Colombia being another, where I think the court has actually not wanted to move in, but has wanted to try to encourage meaningful domestic accountability. I also think Susanna's right that given the egregious nature of Taliban crimes and the ongoing nature, right? Because in the case of the U.S., in the situation concerning U.S., the conduct at issue is sort of in 2003, 2004 primarily. It's conduct that the U.S. decided it did not want to continue for good reason. There was a kind of course correction. So I think even under the prosecutor's own policy with respect to case selection, the Taliban is a much more likely focus for all the reasons that Susanna said. But in terms of what the U.S. should do, let me just mention a few things. One, I think we should calm down, take a deep breath, and ratchet down the threats and rhetoric. Okay, I think it doesn't help us in engaging with the court to be as shrill and extreme as Bolton has been in his speech and make the kind of threats that he's made. The U.S. does not have a legal obligation to cooperate in any investigation. It's restricted by statute from doing so. It's unlikely the court could make any headway without that cooperation. Any potential investigation would take years. So I think there's plenty of time adroitly to navigate the situation and to ratchet down the sort of extreme rhetoric. But secondly, I think the U.S. should be more transparent and forthright about domestic action concerning the post 9/11 mistreatment and torture of detainees. I think the U.S. should be more transparent and forthcoming, first and foremost with the American people, about what has been done to hold people accountable. I think there actually has been a fair amount of effort concerning U.S. armed forces, but it's hard to get full and accurate information about what has been done in that regard. There hasn't been much with respect to holding CIA officials accountable, but I think the U.S. government owes the American people a more transparent account of what has been done and an honest consideration of what more realistically could be done with respect to accountability. I think demonstrating that the U.S. takes seriously the fact that crimes were committed in the torture of detainees would strengthen any U.S. complementarity arguments going forward. Third, I think the U.S. really needs to solidify and reinforce the self-correction on torture. Right now is really an important time for the U.S. to affirm an unwavering commitment to abide by U.S. treaty and statutory commitments against torture. The Obama administration made a strong course correction. There were statutory provisions, thanks to the work of the late Senator John McCain, himself a torture survivor. So there have been a number of things that have been done to affirm clearly that torture and cruel and inhuman and degrading treatment and punishment are forbidden in all places at all times with no exceptions. Defense Secretary Mattis has made clear his opposition against torture. We ought to get a clear statement from the administration on this as well. I think that would be very helpful in engaging with the Office of the Prosecutor. And then fourth, I think we ought to consider making arguments and exploring options consistent with the Rome Statute. I think the kinds of arguments that Susanna was suggesting about case selection and prosecutorial priorities is really something we should look at. And to try to the extent possible, we're not going to withdraw we're obviously going to continue to make, the U.S. government will continue to make its longstanding arguments challenging the court's exercise of jurisdiction, but those are not going to be persuasive arguments within the sort of framework of the Rome Statute. But there might be other arguments that are more consistent with the statute and more consistent with the procedures and so forth that could actually go some way to dealing with the situation effectively.
Can I respond to what both Susanna and Jane said? So, Susanna, I think you've actually laid out exactly the reasons why it was a mistake and unnecessary for the prosecutor to go forward. I get the arguments why she could have, but to look realistically and do a calculus about what is the actual benefit of going after the United States for, as you say, 54 people, when the cost is going to be to, one, U.S. support for the court, and you heard what Jane had said, for basically it's almost 16 years of U.S. support for the court is going to now go down the drain. I mean, it would have gone down the drain in any administration. It's basically going to result in the U.S. Preventing other countries from supporting the court. The U.S., in fact, has provided some of the most intelligence and military support for the court of any country in the world. And to what end? For 54 people. This was not what the court was created to do. It was not supposed to be a sort of super appellate body. It was set up to go after the gravest, most serious crimes in the world in terms of magnitude and so forth. So, just in terms of the cost benefit, and this is where I think, talking about my chessboard, I get I can see how she moved from step 1 to step 2, But precisely as you said, highly unlikely that anything will ever happen. I mean, does she actually think that she is going to prosecute, George Tenet? Highly unlikely. So, at what cost is this to the court? So I think, ultimately she's hurting the cause of international criminal justice. I agree with you at the same time, Jane, on the U.S. Overreaction. Really unfortunate. And I think it's more likely now that because of this loud counter-reaction, when perhaps quiet diplomacy of the sort that Todd was very effective at, might possibly have worked something out. Because in fact, while there may not be precise complementarity, a lot has been done. And, there was discretion for the court, she could have gone either way. But there was discretion for the court to have said, look, the U.S. has done a lot. Maybe it doesn't match perfectly up in terms of complementarity, but there's been a great national debate and dialogue, including in the Congress, including investigations. I have a limited amount of resources. And so, if the U.S. had actually sort of quietly worked with her to show that what had already been done, rather than having John Bolton throw down the gauntlet, as I said recently in a lawfare post, which is going to result in at least some of the pretrial judges likely sort of doubling down because they're said, well, damn it, I'm going to show him. Then I think that is not effective. So, as I said in my lawfare post, I hope the pretrial chamber will not take that bait, and instead of doubling down and saying, we're going to just create a train wreck that is going to hurt the court, I would hope they would actually say, look, on their end, let's all calm down. Why don't we'll take the Taliban part forward. We're sending back that part for further work to encourage the prosecutor to engage in a dialogue with the United States about what has already been done. John Bolton has basically tried to back them into a corner, and I think rather than lashing out and going the next step forward to something that's going to hurt the court itself, and is going to end up shooting the court in the head, is they should look for a way out. If the U.S. is not going to be the adult about it, then the court should be the adult about it.
Just briefly to respond, I think the Afghanistan situation is of a piece. In other words, the problem is that the OTP couldn't ignore the scale of the atrocities committed by the Taliban. And once they've opened the investigation, or they've opened this idea of potentially investigating the Afghanistan situation, then any party to the conflict that has committed crimes could be subject to investigation, right? So it would be hard, given the ongoing nature of Taliban crimes, for her to have continued in preliminary examination. But once it's over the line, right, once it's initiated, then really there's no limit. It's a situation initiated on her own authority, and there's nothing in the statute that would limit the investigation, right?
Do you think that's correct, Todd? I mean, could they accept
The world is a very complicated place.
But it gets to the question, right? That's the question, is that right? And it's not it doesn't fit in with their practice, right? Whether they park it on the other side of the investigation line is a separate thing. But even if it's sort of parked there, even if it ends up being parked there for 100 years, nobody will ever know that it's parked unless they tell us we're putting it there, but wink, wink, we're not going to do anything.
Well, but that same thing happened with Uganda, right? So in terms of the investigation there, the Museveni invited the court to help, prosecute the LRA, the Lord's Resistance Army. And then there was some critiques about, that's just one side, right? And the response of the prosecutor, different prosecutor, Moreno Ocampo, was to say, well, I have authority to once it's before me, I have authority to investigate anyone, right? Both sides. And yet they haven't investigated anybody in the Museveni government, right? They haven't brought any indictments, I should say, against anybody from the government. So similarly, again, it's possible, but they have sort of parked that investigation, much like I would think they would park this.
Right. So it all depends on whether
you can live with a big gray cloud. Might not be livable, but if you get it, can you get it light enough, right?
Right.
I don't know what the conversations were between the prosecutor's office and the Museveni government. You know, Uganda is a state party. Uganda had reverted
Correct.
itself. I mean, we were
Right.
in a different position.
Correct.
I don't know.
But even more reason to then park it, right? Because there could have been or the expectation of cooperation. There is no expectation of cooperation in the case against U.S. nationals.
Right, and which way do you think that cuts them? Do you think that makes them more or less likely? I mean, I heard
I
what you
think
said
it makes
before.
the OTP less likely to pursue the case against U.S. nationals.
And you don't think it makes them more, so, you know, one issue would be, if you sort of break down all the issues, one issue on complementarity would be, what have you done to investigate?
Right.
And it's not like nothing's been done, right?
Right.
There's quite a bit that's been done.
Right.
It's, you know, as Jane points out, it's a little opaque what's been done because we have our own rules about what we'll share and so forth
Sure.
in a Justice Department investigation. And in a case where that same kind of behavior had been done by a state party, well, you know, you bargained for that, right? If they're going to draw inferences, but you're not telling them what you did, that's what you signed up for.
Right.
We didn't sign up for it, right? Is it fair for, it's a sort of fundamental question, is it fair for the court, for the prosecutor, to sort of draw adverse inferences from our non-cooperation, the same way they would if it was a state party? Or should they be treating us differently?
And Todd, I mean, you know, you were on the inside more recently than I was, but the prosecutor's recommendation and request, the pretrial chamber, was largely based on, with respect to what the U.S. had done, a lot of newspaper reports, which is not the way to go about, you know, I mean, it was just not accurate.
No, it was the Senate Select Committee report on intelligence. The
Well,
request.
there was a lot in that, but it was not
yeah.
accurate either, but there was a lot,
That's mostly what it
a
was.
lot in her report was also based on, you know, newspaper articles about what had or had not been done.
On complementary
in
issues.
terms of complementarity issues. And so, you know, that's not the way to move forward accurately. The way to move forward, I don't know what the U.S. would have done, but would have been to have gone forward to the U.S. to say, you know, we have the following specific questions about, you know, we know you've done a lot. We've seen reports about it, but we also know that a lot that's reported is not accurate. And so we'd like to talk to you about what's already been done so that we get a better understanding of it. The time to have done that would have been, you know, before rather than now, because Todd, to answer your question, you know, it's very difficult for any administration, Republican or Democratic, when you're under that cloud, to say, you know, well, we're going to be more cooperative at this point. This is exactly what the Clinton administration faced from the Defense Department back before they were actually under investigation. So I still hope that both sides will come to their senses here to avoid, you know, the step going forward that's going to basically be unhelpful to both sides.
So can I ask a more general question? So the sort of gestalt I'm getting, especially from John, is, you know, whatever happened, this is sort of beyond what they should be doing, right? It's just not the thing for the big international criminal court to sort of deal with. Is there a more sort of fundamental underlying problem? Is that the court is trying to do too many things, that it's overextended? I mean, we do hear an increasing amount of that from states parties. You know, there's a preliminary examination in lots of places. And it's not that there aren't bad things happening, but one wonders how many things the ICC can fix. Do people have reactions to that? Jane, do you have a reaction?
Well, I do think that the expectations challenges are great for the court. I think it is looked to by so many groups, so many victims, to provide justice in some situations where I think it's absolutely appropriate and compelling. So, for example, I think the decision of the pretrial chamber to conclude that forced deportation of Rohingya from Myanmar into Bangladesh is within the court's jurisdiction because it culminates in a crime that, part of the crime occurs in the territory of Bangladesh. I mean, what's happening in Myanmar to the Rohingya is just horrific. It is the worst. And I think that is appropriate for the court to address something of that scale and magnitude. There may be other situations where it's not, where it's maybe extending itself too far. It's complicated, though, because a lot of what the court, I think, is trying to do is catalyze domestic accountability. So in the case of Colombia, there were lots of very severe crimes, and it hasn't sort of moved that next step because it's trying to hover over the situation and made sure that there was some meaningful accountability incorporated into the peace agreement. And I think in its preliminary examinations, I was just looking at the geographical diversity. It's not as if Afghanistan was the only, non-African country. It's Afghanistan, Colombia, Iraq, UK, Palestine, the Philippines, Myanmar, Ukraine, Venezuela. The only 2 African countries under preliminary examination now, I believe, are Guinea and Nigeria. So, I think the preliminary examination scope is more to try to catalyze, but, some of these cases might involve going after non-parties, and I think that gets very difficult and problematic for all the reasons that we're talking about today with respect to the U.S. And the ICC, in addition to the sort of expectations challenges, has a lot of institutional capacity challenges. It doesn't have as much of a budget or many resources. It faces a lot of pushback and opposition from states. I think going forward, I think of it as having sort of twin challenges of defiance and disillusionment, right? I mean, I think it's facing a lot of defiance from even states' parties that it's going after. And it's also facing disillusionment because people look to it and it's not able often to deliver. So I think there really is a question about how, whether the goals should be more modest for the court.
Both of you have now just given the twin reasons why it did not make sense for the prosecutor to move forward. I get all the reasons why, because I get the more idealistic perspective. No country's above the law. We should go after the big countries as well. The United States should be investigated, but you've both given the reasons why. And maybe it's just because I'm a quintessential pragmatist, is, the court is already suffering for all the reasons that you've just said very well. It really can't handle the workload that it's got already. It's getting overloaded. Now it has the crime of aggression. Everybody is saying there's aggression everywhere in the world. As Harold used to say, it's a wobbly bicycle already, and it's going to crash, and now we want to put more stuff on top of it. And then to take a case that involves 54 people. Again, I get the reasons why one could argue in favor, but the realistic perspective, I think, which I wish she had gone for, would be, that would have been difficult. She would have had to take the heat to say, my job is to make sure that this court goes and works in the next decade to go after the gravest crimes in the world where
But
it's really needed.
She has been cautious. So, for example, in the case of Syria, in the case of ISIS, she doesn't have nationality or territorial jurisdiction over Syria or Iraq. And there was a lot of pressure for her to take a case concerning ISIS. In fact, I think you argued that a referral of those crimes should be made to the ICC.
I did write that up.
Right. Those are,
I mean, that's
that's the
those
gravest
were serious,
of the grave. Right.
That was after Prince Zayd said there was actually genocide against the Yazidis.
And yes, and there are some crimes that are so heinous, and sometimes the ICC really is the only possibility for justice. There may be chances to prosecute some people in domestic courts, not the domestic court of the perpetrating nation, but in other domestic courts. But sometimes the ICC has to step in. But in the case, she said, I don't have enough jurisdiction. I'm going to keep looking at it. But the senior leaders of ISIS were, in her view, primarily of countries that she did not have jurisdiction over.
Can I ask the question the other way, though? If you're the court, right, your whole credibility depends on you not being perceived as sort of deviating from the line of justice, right? So if you are the prosecutor or the court, and you are seen as coming up with pragmatic reasons to sort of get the United States out of this or get powerful countries out of this, don't you undermine, or don't you worry about undermining your ability to sort of to carry the moral weight that you need
Yeah,
to carry
yeah.
in order to be effective.
I mean, I think that's another challenge, the sort of legitimacy challenge that the court faces, right? I mean, there are many aspects to this. It is a court, it's designed to be a court, but lives in a world of politics where it depends on states and their cooperation to be effective. It aspires to universality of justice, and yet its membership is partial. So there are lots of challenges like that to its legitimacy. I think one way to sort of move forward is to acknowledge that the court is only part of the story here. It's only part of the larger fabric of justice. And I think the court has been willing to work cooperatively to support places like Guinea and Colombia, domestic action. I think it's kind of relieved sometimes that it doesn't have to take on these cases. So I think thinking of the fabric of justice and the options for accountability more fully and not putting so much weight on the court, I think is something that we should focus on as well.
I think I was just going to signal that we have time for one more question, and John, you're the unlucky person with the question. So you spent a lot of time talking with our allies, Europeans especially, in the second 4 years of the Bush administration. If you were advising them on how they should be talking to us, are there useful things that they could be doing? What is it useful for us to be hearing from them?
Well, I continue to say this to them because I still get to see my legal advisor colleagues and the heads of the human rights offices around the world. I mean, at the time, I said, let's try to work together on the cause of international criminal justice, including how we can work together with respect to the ICC, even though we disagree. I mean, one of the sad things at the time, and Todd, you were with me every step of the way, was, although we had a good discussion, I think they still hoped that, well, at the end of the day, they would still persuade the United States to become party to the Rome Statute. And I would say to them, it's just not going to happen. And so you have to accept that. And if you start from the premise that the United States is not going to become party and we start a different place, then let's work together. And I think there was still this hope that the United States would just sort of come to its senses and join. And so that was then. I think now, I have hope that our European and other allies who can both talk to the Office of the Prosecutor and talk to colleagues in the State Department to try to avoid a train wreck here. I mean, I've again written that we've now we've created we've already had a crash now between the prosecutor and John Bolton, and the question is it really going to get worse? And I still think that it can be avoided, and I hope that, frankly, the friends of the United States around the world and the friends of the court around the world will help us get out of this predicament. I mean, since the administration, I think, is not, to my knowledge, we do not have an ambassador for war crimes right now. The current legal advisor is overloaded with 3 ICJ cases and a lot of other things. That it's just not clear that there's bandwidth in the administration to have what would normally be a direct dialogue between the court and the United States to try to avoid a situation that's gotten bad from getting worse. And so I would hope that our friends around the world who would really not like to see a train wreck that will really hurt the court or has the real potential of hurting the court will try to do something to prevent that from happening.
Okay. Well, unfortunately, or maybe fortunately, we're out of time. Please, these issues will, you could spend hours and hours and hours on sort of each part.
We'll
of
come
this
back
issue.
next week and the week
We'll
after.
have a series. We'll have podcasts on our website, on the Atrocity Prevention website.
Come
coming
back
up.
to the issue of legitimacy.
Come back to, yes. But thank you everybody, and everybody please give a warm hand to our panelists. And thank you very much.